I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to their elders past and present. And I'd like to acknowledge also the work and research being done by members of the faculty and law school in connection with many projects, including constitutional reform and recognition, and express my hope that the ongoing aims of truth, recognition and reconciliation will be realised. It is wonderful to be here to launch issue 41-2 of the University of New South Wales Law Journal, and particularly wonderful to see such a turnout. This is our second launch event for the year, and at the first launch we were pleasantly surprised at numbers, but I think tonight we've exceeded all expectations, so thank you very much. It's always an exciting occasion for the journal to be here at Herbert Smith Freehills. The relationship between the journal and Freehills stretches back a long time indeed to 1982. 2018 marks the 36th year that the firm has been a sponsor of the journal, and it really is no exaggeration to say that the support of Freehills has been an essential component of the journal's growth and success over the years. That support underpins the journal's pursuit of a number of recent initiatives, such as the launch of our online forum, the first of its kind in Australia, publishing shorter form scholarly work that aims to make a timely and responsive contribution to legal academic discourse, as well as the implementation of our strategic vision, the expansion to publishing 4 issues per year, and revitalising the journal's focus on publishing the highest quality generalist legal scholarship. The relationship with Freehills has also seen a high number of journal alumni in recent years come to join the firm as summer clerks and graduate solicitors. It is a relationship which the journal is immensely proud of and tremendously grateful for. I extend a very warm thanks to Freehills, and in particular to James Keane and his team for their ongoing support and their work in putting together tonight's launch, and to Michael Vrasakis, a partner with the firm, who has, I think for the third year in a row now, kindly made himself available to represent the firm at our launch. Thank you. Our particular gratitude must be expressed to our special guests this evening for kindly giving up their time to come and speak to us. The Hon Justice Lucy McCallum of the New South Wales Supreme Court, the Hon Michael Kirby, formerly a Justice of the High Court of Australia, and Professor Arlie Loughnan of the University of Sydney Law School. I think that the high turnout is in no small part thanks to their generosity in being with us this evening. Thanks also must go to the editorial board, whose skill, effort and commitment is really the engine that keeps this whole show on the road. And I would like to also thank the journal's other premier sponsors, Allens and King & Wood Mallisons, for their ongoing support. This issue contains a diverse and interesting collection of articles which make a significant contribution to their respective fields of academic discourse. On behalf of the journal, I thank and congratulate Amelia, the editor of issue 41-2, on this wonderful edition. Her commitment, leadership, organisation and intellect have been a true asset to the journal over the last 12 months, and she deserves to be as proud of the finished product, of which there are still some available if you snap one up at the end, as proud of the finished product as we all are of her. Leading an issue of the journal is an exacting task and an excellent achievement. I'll now pass over to Michael Vrasakis, a partner here at Herbert Smith Freehills in the corporate group and an alumnus of UNSW Law School, to say a few words on behalf of the firm.
Thank you so much, Loughnan. The skill of the person in my position is to speak a few words and to have some clarity around what a few words actually means. So usually I do say a few things about the articles. When I went through the various articles, realised I was very ignorant on most of the topics. I knew I could speak about the Royal Commission. My team challenged me not to speak about the Royal Commission and about anything to do with that. So I just thought I'd say something on an article that did strike my attention briefly, and that is the effectiveness of wellbeing initiatives. I think there's a serious note to be struck in relation to that sort of article. Obviously, it's such an important issue. It's very much an issue that is that people are cognizant of in law firms and obviously in student bodies. I realised, however, as I delved into it, I probably was out of my depth even then, because there were things such as different types of models that were being used, control models, effort, reward, imbalance, organisational justice, I realised that I was somewhat out of my depth. What I did understand was reference to stresses, and I would like to supplement the article to some extent by talking briefly about technology and technology-assisted stresses, or TAS, or technology-caused stresses, TCSs, because what the article doesn't refer to is the myriad of instances during the course of a practitioner's day where one is continually thwarted and feels in combative mode against technology. This, I might say, is a huge stressor. Things like pop-up saying that your paid subscription to Workshare requires a credit card payment when you actually have never made a payment, paper jams in the copier, information barriers preventing actually word processing, typing up your documents, shutting emails on your system, inexplicably linking to the shutdown of your whole Outlook. So on that basis, I'm going to introduce Amelia. I'm just going to mention the word mindfulness because apparently mindfulness is the buzzword, and when I was studying law, mindfulness probably didn't exist. It's probably a neologism now which refers to, obviously, I think we used to refer to meditation, but apparently mindfulness now is the buzzword. So I'd just like to join Loughnan in congratulating Amelia for what is a terrifically diverse group of articles and contributions to the Law Journal, and obviously to congratulate Loughnan and the team for for organising and assembling such a great bunch of panel speakers this evening. So on that note, if I can welcome Amelia Loughnan to the podium and get her to say a little bit more about this edition.
Good evening, everyone, and welcome to the launch of issue 41.2. I would also just like to acknowledge the Gadigal people of the Eora Nation as the traditional owners of this land, and also on the 1-year anniversary of the Uluru Statement, I would like to recognise how far we still have to go in listening to the voices of First Nations people and our ongoing effort to address the intergenerational trauma of colonisation. And now to this fantastically packed room and the very first sold-out launch event, if I may say. Thank you all for joining us to celebrate another issue of the Law Journal and also to celebrate the hard work of everybody who was involved in its publication. I'm very grateful to our premier sponsor, Herbert Freehills, for hosting us tonight and for their ongoing support of the journal. We are also very fortunate to enjoy this support from our other premier sponsors, King & Wood Mallisons and Allens. Now, I know you're all here to see our distinguished speakers, who I've tantalisingly brought up on stage with me, but before I introduce them, you'll have to bear with me a bit longer as I thank some important people. First and foremost, I would like to thank the authors for entrusting your work to us and for continuing the journal's reputation for what is exceptional legal scholarship. It was a privilege to work with you all, and I'm very glad to see a number of you here tonight to celebrate with me. And although the authors probably don't always share this sentiment, I am very appreciative of the anonymous peer reviewers who donated their time and intellectual energy to provide us with rigorous feedback on all the submissions we received for this issue. But the success of our entirely student-run publication would not be possible without the trust placed in us by our law school, especially our Dean, Professor George Williams. He continues the strong support of our previous Dean, Professor David Dixon, who I would also like to thank for assisting me with the development of tonight's event. Our faculty advisor, Professor Rosalind Dixon, has been an endless source of thoughtful advice and encouragement for me at every stage of this process. Thank you for being so generous to students with your time and your energy, despite always having a very full plate of work. Now, guys, if you've got a spare Saturday and you're looking for something fun to do, open this journal and see if you can find an italicized comma or an open parenthesis that doesn't have a matching closed parenthesis. Well, sorry, you won't find any because this journal, there were 5,000, I can assure you. This journal has been meticulously edited by our very dedicated student board. Your idea of fun on a Saturday probably also doesn't involve italicized commas and obscure legal citation rules, but I'm very glad that it is for some of you, so thank you. You know, when I started in this position, I thought I was going to be a big picture editor, focused on common sense rather than pedantic change. And then clearly, after spending too much time with these guys, I found myself awake at 3 a.m, fretting over whether we should use an and or an ampersand in a case citation. I may have also reduced the social value of the journal by banning all non-editing related conversation, but I hope to make up for that by having a drink with you all tonight. I'm also very grateful for the steadfast support provided by each member of the Executive Committee, and I'd especially like to thank Rose, who forged the path for our new publication structure and graciously passed on everything that she learnt in that very hard path onto me. Our digital editor, Se-Yun, also does a huge amount of work behind the scenes of this publication, and I'd like to thank her for all her diligence and her quiet achievements. It means so much to me to have my family, friends and colleagues here tonight. Thank you for your support, not only tonight, but over the past year, as this journal has gradually replaced each of you in order of priority in my life. Finally, and most importantly, I'm grateful for the endless patience of my partner, Loughnan, who has not only been a brilliant executive editor, but bore the emotional labour of my battles against Microsoft formatting and Adobe Pro. Now, sorry, I have such a dry mouth. On to the real reason that you're here. This is the only second issue of the journal in our new publication structure, which involves 3 issues of a generalist nature and 1 dedicated entirely to a theme, which this year is vulnerability in the law. Give me some water. Oh, I'm so sorry, it's such a dry mouth. I'll start again. Now, on to the real reason that you're here. This is only the second issue of the journal in our new publication structure, as I said, so we have 3 issues of a generalist nature and 1 that is dedicated entirely to a theme, which this year is vulnerability in the law, and that's going to be launched in September. Now, despite its generalist nature, as pointed out by Michael, I think it's impossible to detect some key thematic concerns running through issue 41.2. So the first group of articles explores the various interpretive issues faced by legal decision makers. Former High Court Judge Michael Kirby offers a unique insight into judicial fact-finding and the need to approach this exercise with care, scepticism and self-awareness regardless of the legal forum. Stephanie Jowett, Belinda Carpenter and Gordon Tate argue for a more principled approach to findings of suicide in Australian coronial law. Patrick Parkinson and Bruce Chen, respectively, engage with unique aspects of statutory interpretation through the role of judicial restraint in just and equitable property division and family law, and in the contested principle of legality under Chief Justice French. Secondly, there is a strong internationalist perspective on contemporary legal developments. Elizabeth Hansley and Belinda Reeve make a strong case for using international child rights instruments to hold companies to account for advertising unhealthy food to children, while Michael Douglas offers a nuanced legal solution to cross-border breaches of privacy. Alexander Ferguson then critiques the use of domestic administrative law concepts in international investment law. Finally, we have 2 pertinent analyses of current issues in the Australian legal climate. Michelle Taylor-Sands critiques Victorian legislation, giving donor-conceived individuals an unfettered right to access identifying information on their donors. Susan Poynton, Janet Chan, Anne Grinstead and their colleagues report on their 4-year study of the effectiveness of wellbeing initiatives in the legal profession, making an important empirical contribution to the literature on mental health in our profession. And there's one that you've obviously realised I've left out, and that is the article by Harry Hobbs and Andrew Trotter that has informed tonight's discussion on dangerous offenders and the governance of risk. The author's extensive historical analysis reveals how salient incidents of serious sexual offending mobilise legal responses that are overzealous, target individuals, or employ preemptive measures against a criminal class of dangerous offenders. Tonight we will question whether such a class exists and discuss how the law regulates this risk posed by society's most dangerous offenders. We are very honoured to be able to hear both the academic perspective and the practical reality of this vexed question with such an illustrious group of speakers. And it is now finally my pleasure to introduce the first ever panel of the UNSW Law Journal. Dr. Arlie Loughnan is Professor of Criminal Law and Criminal Law Theory at Sydney Law School and the Co-Director of the Institute of Criminology at the University of Sydney. Her research interests include criminal responsibility and mental incapacity in criminal law, and she teaches and researches across criminal law, legal theory and legal history. Arlie is a graduate of the University of Sydney, New York University and the London School of Economics. She is also the author of Manifest Madness, Mental Incapacity in Criminal Law, and her forthcoming book is Self, Others and the State, Relations of Criminal Responsibility. The Honourable Michael Kirby served on the High Court of Australia from 1996 to 2009. Before that, he held many senior judicial positions, including as President of the New South Wales Court of Appeal. Since his judicial retirement, he has been busier than ever, mostly in international activities. He served on the UNDP Global Commission on HIV and the Law, as chair of the UN Human Rights Council's Commission of Inquiry on Human Rights in North Korea, and recently as co-chair of the International Bar Association's Human Rights Institute. At UNSW, he is an honorary Doctor of Laws and patron of the Kirby Institute on Blood-Borne Diseases. The Honourable Lucy McCallum graduated from UNSW in 1986 with a BA majoring in philosophy and an LLB. She worked in commercial litigation at Mallis and Stephen Jack in Sydney, and then as a prosecutor in Canberra and Queensland before returning to Sydney to become a barrister in 1991. She took silk in 2005 and was appointed to the Supreme Court of New South Wales in the Common Law Division in 2008. Outside work, Her Honour enjoys spending time with her children and, subject to an ongoing dispute with her knees, is a keen sportswoman. I would like to welcome Her Honour first to speak, and then she will be followed by Professor Loughnan, and then Michael Kirby will respond and comment. Thank you.
I too would like to begin by acknowledging the traditional custodians of the land on which we meet and paying my respects to their elders, past and present. I feel a little apprehensive speaking tonight. One of the earlier speakers said that the task was to speak in few words. I've been given 15 minutes, and my task is in that time, I think, not to be too subversive. But I think I can begin with the proposition, which I hope will not be characterised as too subversive, that legislation is a blunt tool for addressing future risk or dangerousness. While I was looking for the High Risk Offenders Act to reread the current version, because I always forget that it's an act that begins with the word crimes, I was searching through acts beginning with the letter H for high risk offenders, and I came across a fun fact, which is that contained in the Hairdressers Act 2003, which seems to be an act like the High Risk Offenders Act, also passed hastily in response to an isolated incident that sparked panic through probably both Houses of Parliament, if not through the whole community. The long title of the Act is that it is an act to prohibit unqualified individuals from acting as hairdressers. I imagined this legislation was passed in response to an incident perhaps involving Ray Hadley and his attending a hairdresser, an elegant young man who may have run his fingers through Hadley's hair and suggested he might go for a man bun. Hadley turning to the young man and saying, "Are you even qualified as a hairdresser, citizen?" The Attorney-General hastily responding on talkback television and immediately promising to pass legislation to address the public vice of unqualified hairdressers. The Act seems to have two main provisions. One is that, this is my favourite part, did you know it's actually an offence for a person to to act as a hairdresser for reward, fee or gain unless qualified as a hairdresser. And the Act also provides for some what you might term compulsory powers, which is that a demand for documentation. So you can, as a citizen, or presuming that you work for the appropriate minister, go into any hairdresser and say, "Do you have a Cert 4?" And if they don't produce the document, that's also an offence. But this article by Harry Hobbs and Andrew Trotter treats obviously with a more serious subject, and it is one, as I say, in respect of which I do need to be careful not to be too subversive. But they describe this question of the battleground between liberty and security as a familiar battleground for the old foes of security and liberty, with crossfire between the judiciary and the executive. Now, I would cavil with the term crossfire. Certainly, I think there is healthy debate between the judiciary and the executive about those old foes of security and liberty. I prefer, rather than thinking of it as a battle involving crossfire, as something perhaps involving a more, what might in the olden days have been termed gentlemanly exchange of writing to each other. One of the judges of the district court has a lovely story about the way judges should deal with being overturned on appeal. You shouldn't feel badly about it. The Court of Appeal are our pen friends. We write to them and they write back to us. But I can this evening present you with a real example of an exchange between my pen friends on the executive arising out of a particular experience with a case involving the High Risk Offenders Act, which sits closely next to the Hairdressers Act in Osley. And it begins with the proposition that predicting risk is inherently challenging and empirically impossible, and that's a quote from the article by Harry Hobbs and Andrew Trotter. They use the term and this is again a quote from towards the end of their article, squaring the circle doesn't mean abandoning the protection of the community. And again, I pause again so as to pad the time and not be subversive with another fun fact. I don't know whether they knew that the term squaring the circle comes from a mathematical challenge that challenged mathematicians for many centuries of attempting to calculate the area of a circle literally by squaring it. And there was actually a bill passed in Indiana, a bill presented to the Parliament in Indiana which attempted to solve this mathematical problem that had eluded mathematicians for centuries. In case any of you have forgotten, the area of a circle is the square of its radius multiplied by pi, pi being the ratio of the circle's circumference to its diameter. But pi is a mathematical constant, but it's also an irrational number, so it can't be expressed as a fraction, and expressed as a decimal it's something like 3.14159 continuing. Bill 246 presented to the 1987 session of the Indiana General Assembly tried to overcome that problem by declaring that the ratio of the circumference of a circle to its diameter is 4 to 5/4, or otherwise 4 over 1.25. So in other words, the effect of the legislation was to approximate the value of pi to 3.2. And to mathematicians, this is heretical. And I'm not being entirely flippant, because it seems to me that with legislation such as the high risk offenders legislation, Parliament seeks to derive comfort from allocating what people might regard as a constant value to something that is simply not able to be given a constant value. And so I come to my pen pals on the executive, a case which I decided, and it's over, so I feel comfortable at least talking about the facts of this case so far as they're reported. It was a decision of the State of New South Wales and Donovan. It was a case where a continuing detention order was sought, and under the legislation at that time, the finding which triggered the court's authority to make a continuing detention order was based, as it still is, on the existence of an unacceptable risk. But to the extent that politicians or people who read the Act think that that is a term which has the kind of certainty that you can give pi by calling it 3.2, that is elusive in my view. An issue that arose under the legislation before it was amended late last year, which was the legislation under which I determined this case, was whether adequate supervision could be provided for an offender in the community. So at that time, the Act created a hierarchy which was intended to provide that a continuing detention order could only be made if an extended supervision order would not provide adequate supervision in the community. And there was a contest in the hearing at first instance as to the relationship between that first necessary finding as to whether someone posed an unacceptable risk and whether a supervision order would provide adequate supervision. This is where I think the relationship at a practical level between judiciary and executive, and at a theoretical level between what the authors of the article term the old foes of security and liberty, becomes particularly acute, because a judge in an application under this legislation is presented, leaving aside the difficulties which I think a lot of people don't really have any familiarity with, which is the way in which the judges in the Common Law Division are allocated their work. We receive our work on fairly short notice. We often receive truckloads of folders delivered to chambers the night before a hearing. But what the legislation requires is that the people who work in corrective services, who really do have the greatest familiarity with these individuals and the greatest ability to present what is required in terms of supervision or addressing the dangerousness of a particular person, are expected to effectively square the circle and bring that material into a form that a judge can digest, having it provided to them in folders 2 nights before the hearing, And the judge has the extremely difficult task of trying to make this evaluative judgment or assessment of the extent to which an individual poses a risk and the extent to which that can be addressed by adequate supervision under the old legislation. So in the case of Donovan, I had an anxious task and I concluded that I was satisfied that he posed an unacceptable risk, but I concluded that the proposal put forward for his supervision, which contained a long list of conditions of the kind provided for in the legislation, would provide adequate supervision, and I declined to make a continuing detention order, but I made an extended supervision order. The barrister, when I published that judgment, I pronounced the orders, I refused the application for a continuing detention order, I published my reasons. As my tipstaff was walking the reasons down to the bench, the barrister appearing for the state said, "We want to appeal, Your Honour." And this is all a matter of public record, it's on the transcript, but the intonation which you're going to hear tonight, just confidentially between the 70 or 80 of us, is probably not captured by the transcript. But before the reasons had been seen by the state and when it was announced that there was going to be an appeal, I said in probably a slightly hurt voice, "Don't you want to read the reasons?" And I thought that, arrogant enough to think perhaps when the reasons were read they might have persuaded somebody that I was right. But the decision was appealed, and I'm pleased to say the Court of Appeal did uphold my judgment. What I later learned in the course of preparing for this evening was the angst that caused for, well, I don't know if it was this individual case, although certainly it seems to be an important part of a later parliamentary review of the legislation, because of this vexed question of communication to the court of what is adequate supervision. And the high-risk offenders legislation underwent a review and then amendments were made which came into force late last year. So I went in the course of preparing for this evening to the report of the review, and being vain and self-absorbed, I searched the word Donovan, which was the decision I've just referred to, and sure enough it featured, I think I would conclude from my reading of the review, it featured as an aspect of the submissions that were put forward, which ultimately formulated into recommendations for amendments to the Act, and the Act was duly amended. The review specifically referred to the difficulty, which I've referred to, of corrective services officers being required to put evidence before the court as to what adequate supervision could be provided for an offender in the community, in circumstances where corrective services were of the view that the person couldn't be adequately supervised in the community. But the court had the task of making that assessment, separated from the task of assessing unacceptable risk, and that was seen to be a vice in the legislation which required amendment. So, excited at the prospect of a clearer Act, I went to the amendments, and I have to say, on my reading of the amendment, I think, again, trying not to be subversive or controversial, I think there are still difficulties, and I think they reflect the fact that that you can't square the circle, and you can't give comfort and certainty in a field with the difficult task of predicting future dangerousness using terms of indeterminate reference or uncertain content. So the whole test of adequate supervision has been removed, and the hierarchy between detention orders and extended supervision orders has been removed, but the Act still requires the court to make a determination as to whether it's satisfied to a high degree of probability that the person poses an unacceptable risk if not kept in detention under the continuing detention order sought by the state. And I don't know how you can form that assessment without considering the circumstances in which the person would be in the community if the continuing detention order wasn't made. I haven't, I confess, had time in the last little while and in the course of preparing for this evening to look closely at how the amendments have been analysed, and I don't know whether other judges of the division have the same concern I do. But it just seems to me that ultimately you come back to an intractable problem when you're trying to address future dangerousness through legislation, which is that it is always going to involve an evaluative judgment based on uncertain material, the best material that the people bringing forward the applications can present in large folders to a busy judge, and ultimately the notion that we can give ourselves a confident way of addressing risk through legislation of this kind is always going to be vexed. I wanted to finish by commending the authors of this article. One of them was sitting in front of me before and now he's moved, but I think that the article presents a beautiful analysis of the ways in which there are reactions to occasions of risk which have variously disproportionate or otherwise consequences. And I noticed one of the things that the article did refer to was the possibility of chemical castration and courts ordering chemical castration. That legislation, I think, first came in, or that authority first came in when I was a prosecutor in the ACT many years ago, when I still had functional knees. That's how long ago that was. And the Chief Magistrate in Canberra had an accused person, or an offender who'd pleaded guilty and was constantly trying to get this boy to come on board to a chemical castration program. And I just remember looking at this boy and thinking, wow, that's a large proposition in the case of a young male to have court-imposed chemical castration. So I welcome this very interesting analysis of those difficult complexities that we face in trying to address the dangerousness of people through legislative responses. Thank you.
Good evening, everyone. I'd also like to begin by acknowledging the traditional owners of the land on which we meet and pay my respects to their elders past and present. I'd also like to thank the editors of the UNSW Law Review, especially Amelia, for the invitation to come and join you tonight. As a former editor of Sydney Law Review, I could have been considered the enemy. So I'm very delighted that that wasn't the case. And it's a particular pleasure to be here tonight because I think we have a very important topic to discuss, and I think we have a wonderful article that is the stimulus for the discussion. As Harry and I discussed a moment ago, we already had an exchange a few years ago when Harry and Andrew submitted an article to Sydney Law Review, and that article attracted a great deal of attention, and Sydney Law Review ended up on the front page of the Brisbane Courier Mail because of the criticisms that the authors offered of the previous government in Queensland. As Harry said, it could be regarded as either a high point or a low point of an academic life, but I think he's off to a very good start if that's the kind of attention he can gain. That's the context for my presence here tonight. I'm a big fan of historical reflection on contemporary social problems, and I think it's particularly valuable that we have a piece tonight that sets a wide historical perspective on this very tricky issue of dangerousness. Harry and Andrew's article ranges widely, and once again I was impressed by their relatively sophisticated literary references that they combine with detailed legal study, their wide-ranging multi-jurisdictional coverage of law, and their freedom and reflection to think about contemporary issues in an historical way. As Harry and Andrew's article reminds us, the content of dangerousness has varied very significantly over time. We actually don't have to go back very far, only to the early decades of this century, to find that dangerousness was associated not with sexual offenders, which is the subject of the article of Harry and Andrews, but with property offences, and in particular with low-level property offences. These offences and thieves and low-level offending of that kind was considered to be likely to prompt to be a factor that went into recidivism, and also to be something that attracted genuine social fear and concern. And in my own work on mental incapacity, going back further, we can see over the 17th, 18th and 19th centuries the role of mental incapacity and dangerousness, the connection between the two. The idea that a mad felon, quote unquote, was someone who we needed to be afraid of, not just for what they had done, but for what they might do in the future. Harry and Andrew are right now to draw a connection between dangerousness and sexual offending, and I think they're also right to say this is something of a high point in social and political public concern. They draw attention to the legal concerns that we as lawyers all share with efficacy, with proportionality, with limits on state power, such as are required in particular contexts. And they draw attention to the idea that dangerousness is not a free-for-all. It's something that requires a scoped and careful approach to the offenders that are being labelled in that particular way, and of course, an appropriate recognition of the victims of crimes that they have committed. But dangerousness is not just a legal matter, and it's not just concerns with efficacy and proportionality that we should turn our attention to. And what I want to mention and discuss tonight briefly is the way in which dangerousness borrows clothing, if you like, and it has not only a legal identity, but also a medical or more broadly socio-legal identity. And it's here that I think we can add to our level of reflection about the concept of dangerousness and the role that it might be playing in othering particular individuals in the criminal justice system. So here I want to mention two different types of knowledge that we bring to the notion of dangerousness, because this is the way in which we can see dangerousness having this extra legal life. The first type of knowledge is expert medical knowledge. And here I'm thinking particularly now of psychiatric and psychological knowledge that, from the end of the 18th century and right up to the current era, plays a very big role in the kind of legal determinations of dangerousness and then the responses we make, whether they be in the form of preventive detention, habitual offenders legislation, or otherwise. As we sit in the present era, it's hard to imagine a system where we didn't have reliance on expert medical knowledge. And in fact, we probably wouldn't want to be without it now. But it's worth saying that there was a time when dangerousness and its associations were a matter of lay knowledge. And in relation to mental incapacity, I would suggest that this hasn't entirely gone away. So, in the early modern period and right up, in fact, until the 18th century, dangerousness in the form of, say, for example, madness was protean, but it was also familiar. It was the sort of thing that lay people, family members, neighbours, close associates could speak to when an individual came to be charged with an offence and sought to raise something like the insanity defence, the mental incapacity defence as we now know it. What the role of the medical evidence was as it came into the courtrooms from the very end of the 1800s was, I think, a very kind of clearly helpful role. It was an attempt to provide extra information about a defendant, perhaps to provide reference to other individuals who might be having a particular condition but not be charged with an offence. But at the same time as medical evidence came to be introduced into the courtroom, and we know it played an important role in the most infamous or famous mental incapacity decision, Daniel McNaughton, we actually don't see the erasure of lay knowledge. Rather, what happens is that lay knowledge still has a role on what is now a mixed knowledge field. Lay knowledge plays a role in the jury determination of the value of the acceptability of a mental incapacity defence, for example. And in addition, because we as lawyers are not medically trained, we could say we are ourselves lay with respect to expert medical evaluations, and we bring our own knowledge to cases, whether it be in defence choices to raise particular defences, prosecutorial choices to seek expert evidence, and of course judicial determinations about what it is that constitutes an appropriate outcome in a particular case involving mental incapacity. Now, what medical knowledge did to the concept of dangerousness was pretty profound. It didn't just suggest that dangerousness was something that could be known to specialists, and therefore that we would need to invite specialists into the courtroom in greater ways, or into pre-trial process or post-sentence process in the form of expert evaluations. It also gave us an idea that dangerousness articulates beyond act, beyond the familiar concerns of criminal lawyers with actus reus and mens rea. Rather, dangerousness became a type, something that goes beyond conduct and mental state in a snapshot moment and into character or into disposition, that it articulates over time and space in a way that is very different to the standard concerns of criminal lawyers, with a blink of an eye moment, the moment of coincidence of the mental state and the conduct element of an offence. And I want to suggest that this is really important for our understanding of dangerousness today, because when expert medical knowledge gave us this wider articulation of dangerousness, we came to see it as something that would subsist in a person despite his or her sentence being completed, despite indicators otherwise that might suggest recovery or rehabilitation. And this idea, I think, has stayed with us, such that we've lost some faith in the kind of options that we might otherwise take for offenders who commit particularly serious crimes. The label dangerousness does something particular. The second type of knowledge I think is important to consider in this respect is social scientific knowledge, the knowledge of society. And I think it's not coincidental that when this kind of knowledge was developing also around the same time, that we came to be able to think of our communities and our societies as healthy, just like a body might be. So we came to be able to measure by statistics and other kinds of knowledges the sort of society that we might want, how we were tracking, if you like. And this was, of course, well before our watches that encourage us to do various activities, etc. What it is that we were looking at there is something that we hadn't been able to cover before in the same way. And what that kind of knowledge, that social scientific knowledge did, is it extended the lens, if you like, that we could take on a particular individual's crime. We could then look back into his or her childhood. We could look more broadly outwards into his or her risk factors. We could look at statistics of success with rehabilitation programs and others, and we could go further, if you like, in our claims about what could be predicted on the part of for that person's future. Now, that kind of knowledge we now know as a risk-based or actuarial kind of knowledge. And we also know, as the authors point out in the article, the limits of that kind of knowledge. But one of the things I think we really also need to think about is the way in which we might be blurring some of the lines now, so that some of these types of knowledges are kind of being added together, 2 and 2, and perhaps coming up with 5, to keep up the mathematical metaphors for the night. Because what we may be doing is extending the extent to which we can be confident about future predictions. The role of risk, of course, means that we're no longer thinking about dangerousness as threat or danger, but rather about predictability, about likelihoods, about chance. And do we ever really say that the risk of something is 0? When we recognise the way in which these knowledges are kind of blurring, expert medical knowledge and social scientific knowledge coming together in particular ways, we can better explain things like the sexual predator laws in the USA that the authors also refer to in their article, where really what functions there is a sort of pseudo-medical diagnosis. There's the dangerous sexual offending is what gives rise to the pseudo-medical label that is supposed to then attract, licenses the state then to attract, to give particular kinds of sentences. So it's not just, as the authors say, that that definition is circular, although of course that is part of the problem, but it's also that that provides a legitimacy for a system that is not providing treatment, in fact, but rather providing harsher sentences. So where does that leave us? If we take into account these types of knowledge in our perspective on dangerousness, where are we at the end? Well, what I want to suggest is that we're at a very big question time. And the question I think to ask is what kind of society we want to live in. And the reason this is the question is because, of course, dangerousness is not something that's contained within the criminal law, even when you take into account medical knowledges of dangerousness around it. Rather, dangerousness is the same thing that we're talking about when we talk about threats to security, threats to the state in the form of terrorism, and other concerns that we might have. And so really, things like dangerousness in criminal law are actually just the vanguard of other issues about the kind of organisation of a social system that we might want to reflect on tonight. What kind of social system we would like to live in. And here I want to suggest three things. So this is the world according to me. In other words, what kind of social system I'd like to live in. The first thing is I'd like to see the kind of investment in mental health services and treatment and rehabilitation which would mean that we're not seeing the criminal justice system become a new asylum. I'd like to see the kind of system that doesn't let people fall through safety nets right until the point when we're talking about very serious criminal punishments. I'd like to see the kind of system that recognises the consequences of victimisation, particularly victimisation for children, and to recognise that when it comes to it, that may be something that is effectively having a criminogenic effect. And I think the Royal Commission, to mention it again, Michael, is actually something that is finally painting that picture for us so clearly that we cannot ignore it. And lastly, I'd like to mention that I think it's very important when thinking about dangerousness and sexual offending to actually remember that the vast majority of sex offending is not treated as exceptional. It's not about dangerousness. It's about everyday activities in the home, on the streets, in clubs, outside clubs, around us in the workplace and on campus. And this kind of sexual offending is the ordinary sexual offending of which women are the majority of the victims. And I think it's very important tonight when we're talking about dangerousness and sexual offending to remember that it's that kind of offending that constitutes the vast majority of victimisation. And I think tonight, when we have an opportunity to reflect on dangerousness, we shouldn't forget that we're not labelling certain other kinds of sexual offending as dangerous. Thank you.
It's a privilege for me to be asked once again to be present at the launch of the University of New South Wales Law Journal, Volume 41, Number 2, 2018. It's also a privilege to be here at Herbert Smith Freehills and to be with all of you, colleagues in the law. I don't want to start in what has become the conventional approach by acknowledging the traditional owners and custodians of the land. We all know why we say that. We all know in a legal audience why we have a special reason to say it. We were those who imposed through the law great injustices upon the Indigenous people that requires our country to try to come to grips with the obligation that goes with that. That obligation has an economic component and a political and a constitutional component. The problem with the legal mind is that it's often infected with a virus that leads to excessive formalism and an inability to look past the immediate issue with which we're addressing ourselves into the dark corners of the law. When I heard about the suggestion of the Uluru Statement that the Aboriginal people meeting in Uluru said, what we want is a voice into federal parliament, I had a very typical lawyer's formalistic answer. You can't have that. The federal parliament is there to represent everybody. They're part of everybody, and they'll get their voice with everybody else. Well, they don't want that. They want to have a special voice, an opportunity to speak directly to the lawmakers, not on everything. They don't want reserved seats. They just want to have an opportunity for a voice. And so I began to think about this and began to see that there was more in it than my formalistic answer led me originally to believe. And I think that's also true about the legislation on very dangerous prisoners. It's very easy to say the Act or these acts have been held to be valid. The High Court of Australia has held that they conform to the Constitution. The High Court has said that they don't offend the cable principle. That led me in Farden, or was it Baker, to say cable was the guard dog that barked but once. There have been a couple of little barks, not many. The problem with our law is that unless you get a bit of experience with addressing deep fundamentals, as you do if you have a Bill of Rights in your constitution or even a statute, you're just not going to think in a way that is sensitive to the fact that there are deep fundamentals, such as the gross overrepresentation in our prisons of the Indigenous people. That comes of just applying the law for what are usually minor cases of burglary and the like, and the result is that the Indigenous people are grossly overrepresented. They are the most overrepresented, they are the most imprisoned people in the whole world, even more than the percentage of China and the United States of America for the total population are our Aboriginals in our country. So we need an escape from excessive formalism. I want to pick up something that Professor Loughnan said about character, and it reminded me of something I wrote in the case of Farden. I used the German word Volksschädlinge. Volksschädlinge. My German teacher at Fort Street High School would be proud of my accent. I had a Sprachgefühl, and he taught it to me. Volksschädlinge was the endeavour of the theorists of criminal law in Nazi Germany to move away from this obsessive concern about the crime and the act, and to look instead at the character of the people. Volksschädlinge, you see, were people who were deemed, with the evidence of their actions, to be enemies of the people. And so I tried to warn my colleagues. It didn't have any consequence, and the case is a case where I am in sole dissent, as I was in Baker. People say the great dissenter. I don't like that expression much. it's sometimes used as a means to try to disempower those who speak and see a different thing and speak that to our people. But this is what I said in that case, which was about dangerous, excessively dangerous, very dangerous prisoners. One pattern of intrusion into judicial functions may be observed in what occurred in Germany in the early 1930s. It was provided for in the acts of an elected government. Laws with retroactive effect were duly proclaimed. Such laws adopted a so-called phenomenological approach. Punishment was addressed to the estimated character of the criminal instead of the proved facts of the crime. Rather than sanctioning specified criminal conduct, the phenomenological school of criminal liability procured the enactment of laws describing punishment for identified criminal archetypes. These were the Volksschädlinge, who had harmed the nation. The attention of the courts was diverted from the corpus delicti of the crime to a preoccupation with the pictorial impression of the accused. Provision was made for punishment or additional punishment, not for specific acts of proved conduct, but for, quote, an inclination towards criminality so deep-rooted that it precluded the offenders becoming a useful member of the community. So there's a precedent, you know, to a lot of this, and as was mentioned in the last words of Professor Loughnan, that precedent we're seeing in the punishment of drug offenders and in bikies and in terrorism legislation, security legislation, and the dreadful way our country has dealt with refugee applicants in Nauru and in Manus Island. So, Volksschädlinge, just keep that in your mind and don't forget that I told you about it. And if you're interested, it's in Farden, and Farden is at 223 Commonwealth Law Reports. It was back in the year 2004, so it's quite a way back now in the past, and it's accompanied back to back with Baker. Now, Baker was a case, I don't think Mr Hadley was around back in 2004, Justice McCallum. He might have been, but he wasn't to blame for Mr Baker's faults. But one of that group of special media personalities who try to make our society very, very angry had called a group of prisoners, including Mr Farden, an animal. But Justice Greg James, who'd heard the case at first instance and who was trying to grapple with this legislation that put him into the character of Volksschädlinge, made a number of factual findings about Mr Baker, and the factual findings just didn't appear to support the notion that his character was such that he should have an indefinite punishment. He said, the statistical risk of recidivism is very low. The particular prospect of the appellants achieving rehabilitation is very high. His Honour said the evidence as to rehabilitation prospects was very powerful. Indeed, he said, that was not to any real extent challenged in the case before him. He quoted evidence describing the appellant's conduct in prison as absolutely exemplary. No suggestion of any conduct as would pose a risk to the community. He referred to corroborated evidence that the appellant had tried his best to behave as a peacemaker in the prison system, even when he himself was assaulted. He noted the appellant's own acknowledgement that he would take time to adjust being in the community after nearly 3 decades in incarceration. He quoted expert medical evidence deposing the appellant had accepted his sentence uncomplainingly and had shown for many years a consistent attitude of remorse and insight. The evidence in the opinion of the primary judge supported a view that the appellant could go into the community without reoffending violently. A forensic psychologist was quoted, with apparent approval by the judge, to the effect that the appellant's behaviour within the prison system was exemplary, his work excellent, and he had achieved a great deal by way of rehabilitation. So that was the man, Mr. Baker, for whom there was no remedy under our law. There was no remedy, and he was subject to a valid law which the court would not apply the cable principle to. I also quoted a very distinguished academic. She's now the Governor of Tasmania, Kate Warner, a really great criminal lawyer and a very fine expert in sentencing law. She remarked, "An obstacle to preventive detention is the difficulty of prediction. Psychiatrists notoriously overpredict. Predictions of dangers have been shown to have only a 1/3 to 50% success rate, while actuarial predictions have been shown to be better than clinical predictions. An interesting point, as psychiatric or clinical predictions are central to continuing detention orders, neither are accurate." So that's the central problem with legislation of this kind. But if the Parliament enacts legislation, and if the High Court holds that it's valid legislation, judges like Justice McCallum just have to do their best. Judges like Justice Greg James just have to do their best with this legislation which is so weighted against the Volksschädlinge. This is the difficulty we face in a meeting such as this, where we're thinking about this fundamental problem. Now, there's a very good essay in this collection of this work, which I thought I was coming to address tonight, which was my own brilliant essay on where does truth lie. And part of that is a story about the inquiry into North Korea and the inquiry in North Korea and about the human rights violations. They have Volksschädlinge in North Korea, plenty of them. They're put into detention camps, and their way of dealing with the problem is they look on Volksschädlinge as people who infect the generation before and the generation after. That's what happens in North Korea. If you are regarded as politically dangerous, they not only put you with your acts of suggested antisocial conduct, but they put your mum and dad and maybe your grandpa, and then they put your children in too, because you are infecting society. That's the problem with Volksschädlinge. And now we have President Trump, on again, off again, but he'll probably have a meeting. And you know, it's really led to my real concern, which I can't resolve. Given the tremendous, tremendous peril of nuclear weapons, do we say that even though there are crimes against humanity, and even though the international community said it would always respond to crimes against humanity in the light of the Holocaust, do we say, well, we're sorry, nuclear weapons are just too big a problem. The dangers to society, to the world, are just too great, and we've just got to turn away from that and try to reach nuclear peace and non-proliferation and destruction and stockpiles. So these are the questions we have in society where there are issues of dangerous. It's a kind of risk management that society is undertaking, and the way parliaments and others respond to that is to pass legislation of the kind that was dealt with in Farden and Baker, and that is still being dealt with in the courts. The judges doing their very best, but thank goodness there are judges who are not blinded by formalism and who look behind the words and look at our constitutional arrangement and look at what kind of a society we would like Australia to be. And to the extent that that is permitted by the law, that's a very good thing, and more Australian lawyers should do it. So to the extent that this new volume of the University of New South Wales Law Journal contributes to that objective, and to the extent that the article by Harry Hobbs and Andrew Trotter contributes to it, I think it's a very good thing. Long may academic scholars continue to question a purely formalist approach to the issues that are presented to us by our Constitution, by Chapter 3, and by the obligation to protect the fundamentals that are so easily cast aside.
My name is Roslyn Dixon and I'm the Faculty Advisor to the Law Journal along with Gary Edmond. Like others, I'd like to acknowledge the traditional owners and lend my voice of support to their calls along with other Aboriginal communities around the country for voice in the way that Amelia and Loughnan and now Justice Kirby have invited us to do. So mine is a very happy task, which is to offer thanks on behalf of the faculty. The first thing I want to do is thank our panellists for a really terrific discussion. Justice McCallum started with hairdressing and pie and took us more seriously to a really fascinating case study of the dialogue between courts and the Parliament and the executive government in this area, and reminded us that each plays their constitutional role and together they produce a stronger and more balanced law, but one that inevitably leaves evaluative judgment at the forefront and the centre of this kind of area of discourse. Arlie Loughnan offered a historical approach and one that was socio-legal, and invited us to think about the kinds of knowledge that contribute to judgments about dangerousness and risk, and to draw connections between sexual offenders and the legislation at the centre of Andrew and Harry's article, and judgments about dangerousness and mental incapacity, which Arlie has written wonderfully about. Justice Kirby reminisces very rightly about Farden and Baker, where some of these issues were first ventilated before the High Court and where our current constitutional and legislative framework comes from. Justice Kirby was a prescient dissenter, one might say, in those cases, and reminds us of some of his cogent arguments and reasons in those cases. And his essay in the Journal today traverses other cases, including his role in North Korea, and as he says, the very difficult issues around factual determination and judgments of that kind in North Korea and other human rights contexts. Justice Kirby was very generous in giving only a brief mention of some of his arguments, and I think it is a wonderful statement of the kinds of issues about risk and judgment that the panel has discussed at page 316, where Justice Kirby says the following. Scientists, mathematicians and statisticians search for truthful and reliable data. One might add, no longer in Indiana, but nonetheless. To the extent that they can work with incontestable facts, unwavering digital numbers and symbols, objective observations, and their decisions are rendered safer, the uncomfortable elements of human imperfection can, to that extent at least, be avoided. In resolving disputes and contests over what has happened in the past or what is happening now in individual countries or elsewhere in the world, it is usually not so easy to delete the human element. And the journal, in its full complexity, brings to the fore both the challenge that lawyers face and very many human elements. So I want to acknowledge our wonderful panellists and thank them, but also all of the authors who contributed to the journal. You'll see from reading it that it really is an amazing array of contributions, many multi-authored contributions as well as solo-authored ones that bring an empirical and socio-legal as well as doctrinal perspective. dear to my own heart, many global and comparatively oriented pieces which together form a very, very interesting and seamless whole. As Michael noted at the outset, it's also wonderful to see scholarly work that both looks outward at problems in the world and the profession itself as an object of study. Whether mindfulness works or not is something we all think about every day, and this journal invites us to think about that. I want to thank and congratulate the editors of the Law Journal, especially Arlie Loughnan for the amazing work she has done in conceptualising and organising and bringing these articles together, but all of the members of the editorial team who do such an amazing job of editing this journal. As someone who constantly doesn't remember that the commas are italicised and relies on the kind of brilliant students who do the hard work that you see in this journal to make work come out looking so professional and so clean and readable. We should offer great thanks and congratulations to all the members of the UNSW Law Journal editorial team. I'd also congratulate Loughnan and the other members of the executive for bringing in this new format so successfully this year, and the other exciting initiatives that you heard from Loughnan about, including the online forum. So after tonight, you will see some of the debate tonight continued in that forum, as well as many other interesting short pieces that you can read. The last thanks is this evening the most important one, and that is to Herbert Smith Freehills for hosting this evening. The firm is, as Loughnan says, a long-standing and generous supporter of the journal, but also of the UNSW law faculty. The students and graduates of the law school here tonight will know that they sponsor our library. I am the Deputy Director of an initiative on law and economics that they generously sponsor, and they have long supported the law school in so many other ways. And so to Michael and James and others at the firm who've hosted us this evening and sustained that partnership and support, we offer you a very warm thanks. So my final task is just to pass you back to Loughnan and to congratulate again all of those who made this evening possible.
And my final task is to be the final hurdle between all of you and another drink. And to say a final thank you to all of you for coming. This is the most extraordinary turnout we've had for a while, and one of the most stimulating discussions I dare say we've ever had at a launch. So thank you all very much for coming. Do remain and mingle here outside or wherever you can find space. And we hope to see you at the next launch, which will be in September. Thank you.